Pem, in some of your answers, you have made it clear that you have listened to the evidence given by survivors in this case study. Correct?
Yes.
Is it the position that you have been present at all times in the hearing since the Royal Commission commenced to hear this case study?
Yes.
Is it your intention during this first section of this case study to be present during all of the evidence?
Yes.
Is it the case that you have been accompanied by Ms Karen Mobbs, who is the Director of Proceedings at the Commission and has been so since 2005?
Yes.
And do you understand that it's Ms Mobbs' intention to be present as well for the balance of this first part of the hearing in relation to the case study?
Yes.
Yesterday, His Honour asked you a series of questions, and this is at 14183 from about point 6 onwards in terms of the record. His Honour was asking you some questions about what you perceive the Medical Council's reaction would be on becoming aware of a particular kind of complaint. And at about point 17 on that page, His Honour asked, what would happen today if you got a complaint? Oh no, I'm sorry, higher up. His Honour asked at about point 6, can I ask you this? This is a bit out of sequence, but it's an important question. As I understand it, when you get a complaint at the Commission, the complaint is required to be notified to the Medical Council. Is that right? And you said yes. And His Honour asked, the Medical Council has the power to act straight away, don't they, on receipt of the complaint? And you answered yes. And your understanding is that the statutory mechanism under which the Medical Council would act would be to convene a hearing pursuant to section 150 of the national law?
Yes.
And your understanding is that such a hearing can be convened with great urgency if the circumstances of the case require it?
Yes.
Thank you. Counsel assisting asked you some questions this morning about orders of the tribunal, and particularly the effect of an order that might permit a health practitioner to seek an application for review and re-registration before a tribunal.
Yes.
Is the position, as you understand it, that in such an application the health practitioner would be the party who would hold the onus?
Yes.
Generally, the Medical Council would be the respondent to an application like that?
Yes.
Are you able to tell the Royal Commission what role, if any, the Commission has on such an application?
The Commission would be notified and be aware of the application. I believe the Commission has a right to appear as well, or can apply to the Tribunal to appear. The review also takes into account any other complaints apart from the matter that was the subject matter of the original finding. So if any complaints had been received about that practitioner since the finding, then they would be produced to the Tribunal as well.
So there's a statutory obligation for a tribunal considering an application for re-registration by a health practitioner who's had their registration cancelled, that the tribunal must consider all other complaints in relation to that health practitioner in reviewing that application?
Yes.
And I think, to assist you, that's section 163C of the national law. Is that the position?
Yes, subsection 3 of that section.
Thank you. And in essence, whatever the procedural swings and roundabouts might be, that usually differently constituted tribunal would be obliged to satisfy itself to the requisite standard that the health practitioner was, at the time of the application, having regard to the earlier tribunal's findings and all other complaints, whether the health practitioner could establish that he or she were a fit and proper person to again hold registration.
That's right.
Thank you. I just briefly would like to step you through some different pieces of evidence from you in relation to the issue of information systems. At paragraph 15 of your statement, you say this: from 2004, the HCCC has undergone major changes in staffing and structure, complete procedural reform, the implementation of an efficient case management system and database, and the establishment of performance management systems.
Yes.
In context, do you say to the Royal Commission that those things started from 2004, but you don't assert that they were all in place properly by 2004?
That's right. These things don't happen overnight, and it did take longer than I thought it would take. I'd say it took 5 years before that was all bedded down and in place.
And I think the position is that you talked about tendering and design, and the case management system in its earliest iterations was operative by 2006.
I think that's so.
Is the position that you accept there's a file note from document, this is document 88, a file note from Ruth Robinson that would suggest that there'd been the linking of relevant complaints using the case management system as at least 12/7/2006?
Yes.
Are you able to tell the Commission why you think it was that, notwithstanding that matching, there wasn't a continued matching of that information in terms of managing survivors' either active or dormant complaints?
It's a very serious lapse, and I can't explain it. I can tell you what would happen now is that on receipt of that complaint, all of the history would be checked, and the Commission would not only have the power to, not only assess that complaint for investigation, but also has the power now, since about 2008, to reopen all past complaints and investigate them.
And in 2008, there was a raft of new legislation and some new protocols within the Commission put in place to make sure that complaints were always linked and taken into account. Is that the position?
Yes, and as I said, the assessment brief now will contain a printout of all past complaints of a practitioner. It's an automatic process.
And I think it might have been yesterday, and I'm sorry I don't have the exact reference in the transcript, but Counsel Assisting asked you some questions about referral powers pursuant to Section 26(2) of the Healthcare Complaints Act, and then the implementation of Section 66(b) and other provisions in 28.
99B, I think.
99B, I'm sorry. Is the position that that mechanism, 99B, would more regularly be used now to share information or provide information to the police about relevant complaints?
Yes, the older mechanisms are applied at specific stages of the process, whereas the 99B mechanism gives the Commissioner discretion to disclose at any time, which is more appropriate because it's best to disclose when the information comes in and it's relevant rather than waiting for the end of a particular stage.
It's more flexible because you don't have to wait for a particular point that excites the discretion as it was under the existing but old provision of Section 26(2).
That's right.
In answer to some questions. I'm sorry, there's a little bit of housekeeping. There's some documents that I anticipate that counsel assisting wants to tender that I'll have the witness identify in electronic form, if I may. Yesterday you were asked some questions.
Sorry, there are some documents to be tendered.
Yes,
I think we need them in evidence before we talk about them.
Well, perhaps that's the easiest way. For abundant caution, I'll sit down. Madam Counsel Assisting will tender some documents. Thanks, Your Honour.
Your Honour, there were some documents referred to yesterday by Mr Pem. I have 3 fact sheets to tender, and there are a couple of other documents. Perhaps I'll do them all at the same time. There are a total of 5 documents.
Can they become the one exhibit?
Yes. So there are 3 fact sheets, and the plain English fact sheets. There's one memorandum of understanding dated 2005, and the 5th document is the statutory declaration of Dr. Wollaston's given to
Should they be separated out?
I think perhaps the 3 fact sheets could stay together in one exhibit, and perhaps it would be best to keep the memorandum of understanding separate and the statutory declaration
Well, the 3
separate.
fact sheets will be exhibit 2714. The second document is?
The memorandum of understanding,
That's between
the police and the HCCC.
police. That'll be exhibit 2715. And the third document?
Is a statutory declaration made by Dr. Wollaston,
When?
and that's dated the 3rd of June 2011.
That'll be 2716. Yes, now, are they in the system and you want to use them in the system?
They are in the system now.
Thank you. Thank you. Might the witness be briefly shown on the screen, exhibit 2714, which is the 3 fact sheets? Perhaps while that's happening, I think the tenor of your evidence yesterday, Mr Pem, was that the material to be found in these fact sheets was to be the subject of continued review.
Yes.
Is it likely that as a result of deeper understandings from having first read the survivors' statements as served by the Royal Commission and then having heard their evidence, that some further review to better refine these fact sheets will take place?
Yes.
There's just an example there on the screen, is that one of 3 fact sheets that you referred to in your evidence yesterday.
Yes.
And in answer to Mr Kernaghan this morning, he asked you a question about a particular letter notifying a complainant about steps, and you said that the letter that he showed to you was in a similar form to a letter that would go today. Is that right?
Yes.
But combining that answer with your evidence in answer to counsel assisting's questions yesterday, a letter of that kind would travel with one or other of the fact sheets that are part of Exhibit 2714. Is that right?
I think the fact sheet on investigations would be sent before a letter like that, so, but within close proximity.
All right. As part of a course of
It's
correspondence.
part of the assessment decision.
Thank you. Might the witness be shown Exhibit 2715? Mr Pem, is the position that when HCCC staff at your direction and indeed yourself searched for documents, that at the time summons was issued by the Royal Commission that you were first able to find and it's provided in the tender bundle a memorandum of understanding between the New South Wales Police and the HCCC from 2009.
Yes.
Did those who assist you at the Commission continue to search because you understood that there was an earlier iteration of that memorandum of understanding?
Yes.
And you see here on the screen is a document that's described in its heading as New South Wales Police Recognition Number 03/02703 and headed a Memorandum of Understanding.
Yes.
And that seems to be dated the 1st of April 2005.
Yes.
And is that a document that the Commission has produced to the Royal Commission upon it being located within the HCCC's records?
Yes.
Thank you. Might the witness be shown Exhibit 2716? You gave some evidence earlier this morning in answer to some questions from counsel assisting that, in effect, Rolleston's lawyers had made representations that in circumstances where he was prepared to indicate that he would not seek further registration as a medical practitioner, that the HCCC would consider not proceeding with disciplinary proceedings before the medical tribunal.
That's my understanding.
And a determination was made, notwithstanding that submission, that this was a matter where it was proper for the tribunal to review the matter.
Yes.
Is this the statutory declaration? Perhaps we could go down the bottom just to pick up the date of it, please. Is this a statutory declaration that you referred to?
Yes.
The effect of in your evidence that was declared on the 3rd of June 2011?
Yes.
Your best searches reveal that there was nothing explicitly provided to survivors at the time that the tribunal made its determination cancelling Rolleston's registration and making other orders to make it clear to the survivors that one of the things that was known to the HCCC and indeed the medical tribunal was the fact that Rolleston had indicated that he would never seek to practice again.
As far as I'm aware, that wasn't communicated to any of the survivors.
And do you accept that that, in combination with other material, would have been something that was helpful for survivors to understand?
I think a better explanation about the effect of the order and the process of reapplication would have assured them that it was extremely unlikely that he would ever practice again, rather than the impression that they had is that on the expiration of 4 years he could just walk back into practice.
You understand that really, even if it wasn't put exactly this way, that the effect of the survivors' evidence was that they saw the orders of the tribunal as being almost akin to a period of disqualification with a traffic licence, where there would be, if you like, an automatic entitlement for Rolleston to start practising again after 4 years.
That's my impression, and I clearly saw it as an inadequate penalty.
All right. Mr Kernaghan asked you some questions about the online complaint process and information that is available on the HCCC website. Remember those questions?
Yes.
And I think your evidence is that the vast majority of complaints now come to the HCCC by way of the website.
Yes.
Is it the case that on the relevant part of the website that there's a menu on the side that has online inquiry form, then how to make a complaint, what if a complaint is made about me, making an online complaint, complaint process, and finally a menu called Your Privacy.
Yes.
And if you go into the Your Privacy section, is there an indication that the Commission has a privacy management plan that can be opened up as a PDF document?
Yes.
Does it, the section that comes up when you hit the Your Privacy screen include material such as, although the complaint process is confidential, the Commission is obliged to notify the health service provider complained about the nature of the complaint and the identity of the person who made the complaint?
Yes.
And that there's some more material about steps that can be taken and an invitation if you have any queries or concerns about your privacy to please contact us, and there's a hyperlink as to how that can be done.
Yes.
Thank you. You were asked some questions by Counsel for Survivors this morning to elaborate on evidence that you gave yesterday about training that was available to dispute resolution officers and, as I understood it, intake or assessment officers to make them better skilled at receiving complaints and being appropriately sensitive.
Yes.
When you were asked questions about that yesterday by counsel assisting, you made reference to a psychologist that was retained by the HCCC, but you couldn't remember her name.
Yes.
Do you now understand that that's a psychologist by the name of Gail, G-A-I-L for the record, Johnston with a T?
Yes.
Is the position that you now understand that Ms Johnston provided 2 tranches of training, 1 day each, to different cohorts of staff in September and November 2014?
Yes.
Is it intended, and that was a 1 day training for each set of staff?
Yes.
Is it intended that that would be an annual training?
Yes, at least.
And that's training that is obligatory for dispute resolution and assessment staff?
Yes.
And is available to investigation staff as well?
Yes, it was made available for investigation staff to attend, although it may be that it should be mandatory for them to do.
And among the topics that are covered in a training that is designed to make officers more effective and more resilient in taking complaints, part of the agenda, listening to the stories of trauma and witnessing the pain, fear, helplessness and hopelessness experienced by trauma survivors.
Yes.
And do you, as Commissioner, perhaps have a heightened understanding of the importance of training like that, having heard firsthand the experiences and emotions expressed by the survivors?
Yes.
And in regard to the Commission's, that's the HCCC's, deficiencies in terms of handling their matters?
Yes.
Is it also the case that the Ombudsman's office in New South Wales provides regular training to those cohorts of, if I can describe them as intake staff, in relation to best practice complaint handling procedures?
Yes.
And that's an ongoing and regular commitment as well?
Yes.
Thank you. You, in answer to some questions about the reasoning behind Mr Strickland's interactions with various of the survivors, you stressed that apart from assessing credibility that one of the factors that might have influenced a procedure like that was the fact that for complainants in the health disciplinary arena, as opposed to complainants moving through the criminal justice system, there is less protections in terms of an ability to prohibit or limit questions about, say, prior sexual history or emotional or psychological or psychiatric conditions. I'm not suggesting you said all that, but
Yes, that's my understanding. Yes.
Evidence. Has the Commission, and I don't know that you'll be able to pinpoint the date, but has the Healthcare Complaints Commission ever agitated for those protections or protections like those to be put in place for complainants who are appearing as witnesses for the HCCC in disciplinary proceedings?
Yes, we raised it as part of our input into the reforms that occurred in around 2008, but it didn't seem to engage the other relevant stakeholders.
All right. If this commission, the Royal Commission, formed the view that those kind of protections were desirable to make the disciplinary proceedings better suited to protect the interests of and meet the needs of complainants like the survivors in this case, or indeed survivors of other kinds of sexual abuse, would you see that that would be a beneficial thing in the interests of complainants?
Absolutely. We had a case where a victim of sexual assault collapsed on the floor of a tribunal and had to be taken to St Vincent's Hospital because the tribunal wanted to hear from her. She was not in any fit state to do that, and that was the outcome.
Is the reality of the way the HCCC endeavours to conduct disciplinary proceedings that wherever possible matters will be prosecuted without complainants being required to give oral evidence?
Yes, our director of proceedings is very sensitive to those issues, and we try to make it as easy as we can.
Could I just have a moment, Your Honour? I'm sorry. Do you understand that you were asked some questions, I think, by Ms Gallagher in relation to the Victims' Charter of Rights? Do you remember those questions? Is the Legal Services Division Procedures Manual one of the documents that has been provided to the Commission at tab 369 of the bundle?
Yes.
And have you reminded yourself that there's an explicit reference in that material to the Victims' Charter of Rights?
Yes.
Is it the position that organisationally, while you sit as the Commissioner above all other staff that report to you, that you would have less hands-on involvement with the prosecution side of things because of Ms Mobb's role, and that you would be more readily familiar with the detail of assessment and investigation matters?
Yes.
Is it... There's only two other areas, Commissioners. The tenor of your evidence, Mr Pem, has been an acceptance of delinquency, inefficiency, a lack of sensitivity, in some circumstances personally, but institutionally across a period from at least 1998. You accept that?
Yes.
Is it the case that you have instructed me to approach council to council the barristers representing each of the survivors who are represented here.
Yes.
Was the purpose of that to make the offer if it were something that each of the survivors wanted to take up, that you would hear what they had to say to you firsthand, and that you would proffer a personal apology to each of them in a way that was comfortable to them, either in terms of the location and the personnel present or not present?
Yes.
Is an additional offer that you've made to one of the survivors and is under consideration, and that you would be prepared to make to other survivors, is if it were a helpful part of their continued healing, that it would be helpful for you, for your purposes of continued cultural change, to have that survivor, or indeed a group of survivors, address your staff about the impact of insensitive, formulaic and, in some cases, delinquent handling of their matters?
Yes.
And is that an offer that effectively remains to be negotiated in terms of the safety and the sensitivity that could be dealt with?
Yes.
Ms. Kumar's client has explicitly asked for a formal apology, and although it's implicit only in terms of the other survivors' statements, either statements that are before the Commission where there has not been oral evidence, or where survivors have given oral evidence, there's I suppose, an implied invitation that there are matters that could be properly apologised for. Now, I accept that you have an intention of personally apologising if that's a course that each survivor wants, but is there something very short that you wanted to say to make it undoubted that you, as the Healthcare Complaints Commissioner, both in terms of your own role and the institution, make a formal apology on the record? And if so, would you do that now?
Yes, I do absolutely unreservedly apologise. Commission made this much more difficult for them in an already enormously difficult situation, and anything I can do now, or the Commission can do to convince them of the sincerity of that apology, I'm happy to take up with them.
They're the further questions, Your Honour.
Yes. Dr. Bennett, do you have any questions?
Nothing further, Your Honour.
Thank you, Mr. Pem. You're now formally excused.
Thank you.
Yes.
I call Professor Peter Prokopis.
Will you take an oath on the Bible or an affirmation? There's a Bible there, if you take it in your hand, please. And repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give in this Royal Commission
that the evidence I shall give in this Royal Commission
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Yes, thank you. Take a seat, please.
Thank you. Professor, can you state your full name?
Peter George Prokopis.
And you've prepared a statement to assist the Royal Commission, and that's dated the 23rd of April 2015.
Yes.
And you've read that statement recently,
Yes.
and it represents, it's true and correct to the best of your knowledge and belief.
Yes.
It'll become Exhibit 27-17.
Professor, could you please set out your qualifications?
My medical qualifications.
Medical
yes.
qualifications.
I graduated from the University of Sydney in 1964 as a MBBS, and gained fellowship of the Royal Australasian College of Physicians, or membership of the Royal Australasian College of Physicians, I think in 1968, and fellowship in 1973, I think.
And what general area of medicine do you work?
Child neurology.
Okay. And in terms of your relationship or your association with the medical board, can you just set out chronologically when you first became involved?
First became involved in 1999 as a nominee from the Royal Australasian College of Physicians, and soon after was made chairman of the board's conduct committee, and then I was appointed as deputy president of the medical board, and in 2005 became president, which I've been since. And in 2010, the medical board, as a result of national registration, became the Medical Council of New South Wales, and I continued on as president up to this time. My term of presidency ends at the end of June this year.
And how long is each term, Professor?
It is a standard term, but because of the national registration, things were carried on, changed, etc. But now the maximum amount of time that one can serve is 9 years. It used to be 12 years, but because of national registration, because of the changeover, it was extended up, and that's how I have come to outlive my time.
Thank you. Now, in your statement, you've set out some of the background and given the Royal Commission some information about how the Medical Council operates. At paragraph 14 of your statement, Professor, you set out that the Medical Council, which was formerly the Medical Board, is a statutory authority and it's established to manage complaints and notifications, etc., in relation to conduct. Now, further into that paragraph, you state, the Medical Council also monitors practitioners' compliance with conditions or orders imposed upon their registration.
Yes.
Can you just give a little explanation of how it is that the Medical Council monitors conditions?
Yes. We actually have a monitoring system section in the council, and they look at the conditions that a doctor has and regularly monitor the doctor's compliance with those conditions. That's a specialised section of the council.
Right. And in terms of monitoring, you have people, human beings there in the office of the Medical Council.
Yes.
And if, for instance, a practitioner, and I'll use Dr. Rolleston as an example, is in Broken Hill, for example, and he's performing his work as a doctor in Broken Hill, how is it that the monitoring group at the Medical Council will monitor his compliance with conditions?
It clearly depends on the conditions the doctor has, but if we talk about Dr. Rolleston in Broken Hill, his conditions that were being monitored later in the piece were conditions requiring that he not see patients without a chaperone, and there had to be a signed consent form, a signed form that he actually complied with those conditions, and they were sent. Those forms were sent to the Medical Council on a weekly basis, and people would then look at those forms to make sure everything was okay. And then if there's an issue about the age of the patients that he could see, for example, not being able to see patients under the age of 10 at all, there is a system where we check with Medicare to make sure that those conditions are being complied with.
Mm-hmm. So in terms of the weekly checking, though, it's rather like a self-monitoring system where he's having to fill in forms and sign them that he's complied with it, and then he'll send it into the Medical Council.
And the chaperone has to sign it as well.
at the same time.
At the same time.
Right. At paragraph 16 of your statement, you've set out that the positions of the President and the Deputy President are prescribed in Schedule 5C of the national law. In terms of the positions more generally of members of the Council, what sorts of background do they have?
Sorry, could you repeat the question?
The members of the Medical Council, well, first of all, how many members constitute the Medical Council?
Over the years, it's varied from 20 down to 19. And there are a number of ways where members will be given the opportunity to serve on the Medical Council. Firstly, there's a number of colleges that nominate members of the Council. And as I said earlier, College of Physicians is one of which I was the nominee. And as well as that, the AMA, Australian Medical Association, has two representatives. There's a representative from the Community Relations Commission, and there are 6 ministerial appointments as well. So it's a combined from colleges and outside groups, including the AMA. The university, prior to, I guess, about 2012, the universities, they still do, the universities have a nominee as well. Prior to about 2012, the Department of Health, now the Ministry of Health, had a nominee, but that's no longer the case.
Right. And in terms of the representation of the colleges, overall, are the majority of members of the Council medical practitioners?
Yes.
At paragraph 18, you've stated that complaints may be received by the Medical Council from complainants directly, and that's been the case since, during the whole of the period before the national law in relation to the Medical Practice Act also.
Correct.
At paragraph 20 of your statement, Professor, you've said the first point of contact for written complaints received by the HCCC or APRA is the administrative assistant. And I was just wondering if you could just clarify that statement, because I'm interested to know, could you assist the Commission to know whether you're talking there about the complaints that come directly to the Medical Council?
Yes, the ones come directly to the Medical Council.
Right. And is this administrative assistant somebody that's there within the Medical Council?
Yes.
Is this system with this administrative assistant somebody that would have been around before the change to the national law?
I can't answer that for certain, but the system is that the complaints are received and then immediately go to a member of the conduct section of the council. If that person in the conduct section who's been used to dealing with conduct matters sees it as a serious complaint or possibly a serious complaint, they'll immediately refer it to the head of the conduct section, who's a very experienced person, who then will confer with the medical director as to the seriousness of the complaint.
Now, you've also referred to a monitoring and complaint system that the Medical Council has, and it's the Medical Council's database. How long has that system been in place, Professor?
I can't give you an exact answer to that. That's something that I would need to check with the executive officer of the Medical Council, but it has been in place for some time. And all I could say is that we had the ability to look at complaints against one single practitioner, their past history of complaints, before the Healthcare Complaints Commission had that in place. Hence the reason that in 2006 or thereabouts we were able to put those two complaints up against Dr. Alston together.
And you're suggesting that in fact it was based upon an electronic matching rather than somebody who just happened to notice?
Electronic matching, yes.
From paragraph 22, you're setting out the different roles of the Medical Council as opposed to the Healthcare Complaints Commission, and you've referred to the fact that things work in a co-regulation type manner. Towards the end of the bottom second half of paragraph 24 there, you've said the purposes of the consultation is to ensure balanced co-regulation, combining the independence and complaint handling knowledge and experience of the HCCC with the profession's specific input from the Medical Council.
Yes.
Now, here you're referring to the fact that the Medical Council is peopled by medical practitioners who understand the clinical and professional issues that relate specifically to doctors?
That's correct. And in addition, as I mentioned earlier, a number of community members who will also have input from the community's point of view.
Right.
Professor, from the outside, it looks like a cumbersome system. Two bodies intersecting, concerned with the same issues, and then a tribunal that sits in judgment, as it were. It looks complex and complicated. I assume there's a history, though, that led to this complicated system emerging because of the different interests involved. Is that right?
Yes. As I think the Healthcare Complaints Commissioner said, the complaints unit didn't start until the mid-80s, whereas the Medical Board previously dealt with it all. And the co-regulatory system, I believe, although to someone who is not used to it does seem cumbersome, is in fact has the required checks and balances, which I think is a superior system to the rest of the country, where it is or almost the rest of the country, because Queensland's now an exception, where it is the Medical Board which deals with most of these matters, who then receive complaints, deal with complaints, prosecute complaints, and monitor conditions. And that's certainly much simpler, but I think it lacks the checks and balances that our system has.
Just following on from that question then, Professor, you've said on the one hand there's the Healthcare Complaints Commission and that's got the checks and balances. That's a system where at a procedural level it's quite complex. And am I right to think when you say checks and balances, the Healthcare Complaints Commission is required, its hand is forced, if you like, by all the statutory regulations, and no matter if the Healthcare Complaints Commission is working at its peak, it still is required to go through certain steps before it can get to a conclusion. Is that what you mean by checks and balances?
No, not entirely. I mean, because you referred to the profession-specific input, which I think is important in that. And there have been numerous occasions where, and we could use some of the examples in this commission, where the Healthcare Complaints Commission has decided not to proceed any further, whereas the Medical Board or Medical Council has insisted upon an investigation. And at every step of the way, there is consultation. Now, the Healthcare Complaints Commission or the Board or Council can insist on an investigation, and whichever party insists on it, the other party has to agree. However, at the end, the Commission has to consult with the Medical Board or Council, and they listen to what we say, but they don't necessarily have to agree. And we've had some fairly vigorous discussions from time to time about that, but and the Commission many times will change their mind and agree with Medical Council Board, and the same thing applies to the Director of Proceedings, and she again needs to consult with the Board before going on to disciplinary action, but she may or may not agree.
Right,
Just so people understand clearly, if the Healthcare Complaints Unit decides not to prosecute a matter in the tribunal,
Yes.
that decision requires consultation with the Council.
Yes.
And can the Council unilaterally take a matter to the tribunal, or is it bound ultimately by the Healthcare Complaints Unit's decision?
It's bound by the Commission's ultimate decision.
So in terms of prosecuting before the tribunal, the ultimate power rests with the Healthcare Complaints Commission.
Yes, correct. Just to fill in one little bit of detail, if I may, is that there are two prosecuting hearing bodies. One is the tribunal, which we've just been talking about, which has the power to deregister a doctor and also has the power to put conditions on, etc. And the more serious cases go to the tribunal. Rollison is an example of that. The less serious cases, but still need a prosecution, go to what's called a Professional Standards Committee. And the Professional Standards Committee is chaired now by a lawyer, and with some nominated council members specific to the doctor's professional qualifications. They have the power to put conditions on, but they don't have the power to deregister a doctor. On occasions, if the Professional Standards Committee think that this is more serious than was expected, they have the option to escalate it to a medical tribunal, which is now the NCAT.
And the taking of a matter to the Professional Standards Committee, can that be done by the council or?
No, again, it's the prosecution has to be agreed to by the Director of Proceedings and from the Healthcare Complaints Commission.
Yeah.
In that sense, would that mean that a complaint, even if it originated with the Medical Council, would have gone to the Healthcare Complaints Commission, at least for investigation, and that decision would be made after the investigation, and that decision is then made as to whether... At what point is that decision made?
After the investigation.
After the investigation.
For prosecution, you mean?
Yes, the prosecution.
Yeah. After the investigation, the Healthcare Complaints Commission, their first decision to make is whether to prosecute or not, and that's where they consult with counsel. And as I said, sometimes we agree and sometimes we don't agree. And their decision to prosecute then has to be confirmed, if you like, by the Director of Proceedings, who makes an independent decision as to whether she thinks prosecution is justified on a number of grounds. And before that decision is finalised, the Director of Proceedings needs to consult with counsel about that decision. And if counsel disagrees, we will have a discussion about that. And as I said, the Director of Proceedings will have the final say, but the council will put its view before her.
Dr. Bennett, if you're moving to another topic,
Yes, I am.
We might take the lunch and adjournment and come back at 2 o'clock.